Jefferson County Court at law number 2 is back in session. The court is in session and calls numbers 23 CCCR 1562. Case is styled the state of Texas versus Daniel Javon McCray. Mr. McCray, would you please come forward? Where did it? Mr. McCray, how are you doing? Mr. McCray, I have a dismissal of your case from the Jefferson County District Attorney's Office, and I'm signing this dismissal. You should be able to get a copy of the dismissal in a few minutes from our court clerk. Just have a seat in that first chair. Jefferson County Court at law number 2 is back in session and calls number 23 CCCR 0484. Case is styled the state of Texas versus Christopher Living. Mr. Living, would you please come forward? Now, Mr. Living, would you please raise your right hand? Mr. Living, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, Mr. Living, previously you came before the court and you acknowledged that Your signature and initials was on judge's explanation of rights to defendants without attorney. Is that correct?
Yes, sir.
You also previously acknowledged that your signature was on the waiver of counsel for purposes to enter guilty plea or proceed in the trial. Is that correct?
Yes, sir.
And you acknowledged that you read these documents and everything in these documents are true and correct. Is that correct? Okay, now I have another document for you. Bailiff Ms. Bailiff, could you hand this to Mr. Living? This document is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over these bond conditions with you, and it reads as follows. Funding erects and or accusation in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol anytime it's directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. Now, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay.
No, what's the charge?
Assault. Now, your case is going to be reset to give you an opportunity because you are pro se. Oh, let me do this here before we go any further. Okay. Now I need to give you what is called a Faretta warning. It's from the Faretta versus California, 422 US 806. Anytime a person is pro se and they want to go to trial, I need to ask you some questions. Okay. Now, Mr. Living, have you ever studied law? No. Have you ever represented yourself in a criminal action?
No.
No? Okay. Do you understand the charges against you? You do? That's good. Are you aware of the maximum penalty range for the charges of Class A misdemeanor? Okay, I think I mentioned it to you earlier during board hour. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the Jefferson County Jail, which is a year, a fine from $0 to $4,000, or you could be given both such fine and confinement. That's the range of punishment for a Class A misdemeanor. Your case is a Class A misdemeanor. Now, you may be eligible for, if convicted, you may be eligible for deferred probation or regular probation. Deferred probation is a form of probation whereby if you successfully complete the probation, it would not result in a conviction on your record, and you may qualify for non-disclosure. A non-disclosure means that we cannot disclose the fact that you want deferred probation to the general public. However, the governmental agencies can have access to that information. We understand that. Now, regular probation, we call it straight probation, does result in a conviction and record. However, there's something that is called judicial clemency, whereby the court can set aside your conviction, which means you would not have a conviction. Now, in order for that to happen, a couple of things has to occur first. You have to first successfully complete the probation. you have to be successfully discharged from the probation, and it cannot be any more time left on your probation. And if those things happen, then the court can set aside the conviction. And if you get a subsequent offense later on, then the case can be revived, brought back up, and used against you. And if you try to get a license with CPS, then they can deny giving that license. If you have a license, they can revoke it since suspend that license. All right. Now, my next question is, are you familiar with the exact legal elements of each charge, of the charge? Do you know what have to be proven in order for, beyond a reasonable doubt, in order for it to result in a conviction? Okay. Do you realize that if you represent yourself, you're on your own? And as the judge, I cannot tell you how you should try the case or even advise you as to how to try your case.
I'm gonna give it a quarter point.
Okay, so you want to
Yeah.
see if you qualify for court-appointed lawyer? All right, now let me do this here. I think you had previously filled out an affidavit of indigence. Okay, now I did look at this. Now, let me do this here. This document that I'm showing you is titled Jefferson County Affidavit of Indigence. And do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, before you signed and initialed this document, did you read this document? And did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, now I'm looking at the information that you provided in this document. And so let me do this here. I'm going to go off the record right now because there's some financial information that's included in this document. And you have a right not to have this financial information disclosed to the public, even though pursuant to Article 1.27, I think, of the Code of Criminal Procedure, all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365, Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as the non-disclosure of public information, of non-public information, and this is what you have here. And so if you desire to have this case closed to the public, you can do that. Would you like to do that? Okay, so the court finds that the party who's going forward with this motion to close this hearing has advanced an overriding interest that may be prejudice to him in that it would disclose non-public information. The court finds that this request is not an overriding interest, but the court finds that the court has considered other reasonable alternatives to the closing of this hearing. And based on that, the court finds that these findings are adequate for the closure. Okay, so this hearing, this will be closed. Now, Mr. Living, showing your docket that's titled Jefferson County Affidavit of Indigence. And is this your signature on this document?
Yes, sir.
And before you sign and initial this document, did you read the document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
And I've just read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lindsay Scott. Attorney Scott will be given information to contact you, and you will be given information to contact her. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you'll be free to go. And you have a blessed day. And just have a seat in that first chair by the wall. Oh, okay. Yeah. Oh. Christopher. This is this is the other guy, McCray. We don't need this. His case was dismissed. She's gonna shred it. That's gonna be shredded. Need a paperwork on Miss Melissa Van Loo. Is that it? Thank you. Melissa Van Loo. This is- Jefferson County Code at law number 2 is in session in two cases, cause numbers M333690 and cause number M333694. Both cases are styled the state of Texas versus Melissa Noel Van Loo. Ms. Van Loo, will you please come forward?
Sorry. I need a phone number. What's it say? Phone number?
Ms. Van Loo, your full name is Melissa Noel Van Loo.
Sir.
Ms. Van Loo, would you please raise your right hand? Ms. Van Loo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Van Loo, you may put your hand down. How are you doing, Ms. Van Loo?
Great.
That's good. Ms. Van Loo, you have a right to have a court reporter dictate everything that is being said in this court, in your case. Also, you have a right to waive or give up your right to have a court reporter. Do you waive or give up your right for a court reporter?
I don't need it.
Okay, so you don't need, so you're waiving your right to court reporter. Now, Ms. Van Loo, in cause number M333690, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Melissa Noel Van Loo, on or about October 17th of 2022, while you were in Jefferson County, Texas, that you committed a Class B misdemeanor offense of theft. Do you understand what you've been charged with? And to this charge, Ms. Van Loo, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
Yes.
Now, Ms. Van Loo, I also have before me a document that is titled Misdemeanor Plea Admonishments. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials. The first set of initials is on a line next to a box that's checked nolo contingere, which means no contest. Did you place your initials on this document? The second set of initials is the lower paragraph that is titled Discovery Admonishment, and is on line next to a statement that states, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 2, actually page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Ms. Van Loo, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Ms. Van Loo, I also have another set of documents that's on paper. The first document is titled Judge's Explanation of Rights of Defense Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Or these your initials on the line that states I waive my right to attorney and I want to represent myself?
Yes.
And I also have another document here that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on this document?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Van Loo, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit 1, state like off State's 1.
Yes, sir.
Ms. Van Loo, I have before me State's Exhibit Number 1. State's Exhibit 1 is the first document that you acknowledge. You acknowledge that your initials was on page 2 in these 2 locations.
Yes, sir.
And you also stated that your signature was on page 3.
Yes, sir.
State would like to use this document as evidence in your case against you. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit Number 1 will be admitted. Ms. Van Loo, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Ms. Van Loo, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty no contest, state agreed to recommend 1 year to further adjudication, community supervision, $500 fine, court costs, 40 hours community-based service, and restitution of $628 to be paid to Jesse. I believe it's Ramirez.
Jesse Ramirez.
Is that what the docket? My paperwork.
Yeah, Jesse.
Okay, Jesse Ramirez at HEB.
Okay, and I think is, okay.
It's an HEB loss prevention employee.
Okay, Jesse Ramirez, okay.
Now, this plea agreement is also going to run concurrent with the companion case. It's gonna be exactly the same terms on both of them. And
M3.
however, in that case, we don't have a restitution.
694. Okay. Now, let's see. I need to get your court cost.
Hey, in the hospital for the court, it is that.
$27. Okay.
Yeah. What is it? 2399019. Thank you.
I think 628. Okay. Ms. Van Loo, the state is offering that you serve 1 year deferred adjudicated probation. During the probationary period, you'll be required to pay a fine of $500 plus court costs, $327. You will be required to pay a probation fee, $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee, $15, and restitution in the amount of $628 to Jesse Ramirez. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $215 a month. Will you be able to pay the $215 each month? I need to know, will you or will you not?
Yeah.
Okay. Now,
Because I think she needs to know what I've explained to her, the court will explain, is that she's gonna be on simultaneous probation, and some of those fees will only have to pay it once.
well, yeah, the probation fee and the reimbursement fee, you won't have to pay that twice.
Over the community service hour, it's not 80, it'll be 4.
They're running at the same time. That's what it's called.
Okay,
Just make sure you understand, it's not.
and then I could get credit for the $100 for the night in jail, correct?
Um,
Or how does
If-
that
Well,
work?
we don't get, I mean, you're doing deferred, we don't give the,
Okay, that's right. I just heard
It's
what you said
not-
earlier.
should.
yeah, you can't, yeah.
Should you go to jail, but we're doing
We'll
deferred,
have to do-
you don't get the credit back.
this.
Yeah, yeah, you'll have it. Like I said, if,
You get,
God forbid, if your probation is revoked.
you'll get that at that time, but we're not. gonna talk
Right.
about that, 'cause we're not gonna do it.
Gotcha, not everybody.
Okay. Now you said you'll be able to pay the 215 a month, is that correct?
Yes,
Now, do you understand, in this case, and you also be required to perform 40 hours of community service. And as I mentioned earlier, you had restitution in the amount of $628 to Jesse Ramirez. And this case will run concurrent, which means at the same time with your companion case, cause number M333694. Ms. Van Loo, do you understand the state's offer?
yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Van Loo, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Van Loo, I'll proceed. I'll move on to your next case. And your next case is cause number M 333-694. And I have an information in this case that was also filed by the Jefferson County District Attorney's Office. Is it? And in this information, Ms. Van Loo, it alleges that you, Melissa Noel Van Loo, on or about September 30th of 2022, while you're in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Van Loo, do you understand what you've been charged with in this case?
Yes, sir.
And to this charge, Ms. Van Loo, how do you proceed? How do you plead? Guilty, not guilty, no contest?
No.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Van Loo, I also have a document here that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are 2 sets of initials. First set of initials on the line next to boxes check no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. And did you place your initials right here on this document? On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And the next document is titled Trial Court Certification to Defense Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case, and you have the right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement?
Yes, sir.
And again, Ms. Van Loo, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. State, I have before me states one, state like off states one.
Yes.
Now, Ms. Van Loo states in this case is often states exhibit number 1. States number 1 is the document that you acknowledged earlier, the same document that have your initials, page 2, and your signature on page 3. And is it all right for the state to use this document as evidence against you in this case?
Yes.
Okay, no objection. State's exhibit number 1 will be admitted. And again, Ms. Van Loo, is there any evidence that you're mentally incompetent to stand trial in this case?
Yes.
Okay, Ms. Van Loo, I would accept your plea of no contest. I will find that you're mentally competent to stand trial. I also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty and no contest, states agreed to offer the same exact plea agreement we did with the previous case. 1 year deferred adjudication, community supervision, a $500 fine and court costs, 40 hours community-based service.
There's no restitution
No
in this one.
restitution. That's the only difference between the previous.
And cases running concurrent.
Exactly.
Okay. Say there won't be any probation fees or those. Okay. Uh-oh, this went out on me. Two. Okay, now, Ms. Van Loo, the state is offering that you serve 1 year deferred adjudicated probation. In this case, during that 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $337. Now, you will not be paying probation fees in this case because you were paying probation fees in the previous case, and you will not be paying the restitution, your analysis fee because you were paying probation fee. However, you will be paying a restitution fee of $15. Now, your total monthly installments, that is the total amount that you'll be required to pay each month. In this case, is $77. Will you be able to pay the $77 each month?
In addition to the 215?
Right.
Okay, that's not including an additional 500 a month, is it? Because it was.
That it's not 500 a month.
I mean,
No.
500.
Yeah, your fine is in there. That when we break it down, it comes out to $77 a month.
Okay, well, he said there was only one fine.
No. He said that when he says that community, you giving her one fine, it's a zero in the second case?
It's 500.
Oh,
Oh, I wasn't aware of that, but
I mean, there's I can't do zero.
okay. Okay, that's what I thought. Okay.
I don't wait to find out.
No, I thought because I consecutive, that's error, I didn't.
But
no, I think what he was,
community service hours the fee, you're not gonna have double fees. You're not gonna have
The
double
fees is-
community service hours. The
Okay.
fine doesn't.
Okay.
the probation fees is not gonna be double. That's why I mentioned to you that you will not be paying probation fees in this case, and you will not be paying a urinalysis fee in this case,
Okay.
because
I
you're
just
paying it in the
misunderstood.
other case.
So that's my fault.
Okay, so my question to you, will you be able to pay the $77 each month?
I don't think I can exceed 200 a month, honestly.
Okay, now let me do this here. Does she have
The
a,
state doesn't mind waiving the fine, Judge, if that'll put it to where it can be.
it's still gonna be more because it's 215 in the
I
first
could
case.
do
Understand.
215, yes, sir.
Yeah, okay, let me do this.
They'll waive the fine.
Okay, hold on a minute. So it's state waiving the 500 fine in the second case.
He does not have enough of it.
Okay, thanks. Seven. Okay. Because the state has waived the fine in this case, your probation fee, well, your fees each month in this case is $32 a month. Will you be able to pay the $32 each month?
Yes, sir.
Okay. Now, Ms. Van Loo, do you understand the state's offer?
Yes, sir.
Think the state's offer in your case is fair and just?
Yes,
And do you accept the state's offer?
yes.
Okay. Now, I'll follow the plea bargaining agreement that you entered into with the state. Now, when you get to probation, they probably gonna, in your judgment, it's gonna show the probation fee and your analysis fee. However, when probation see that your cases are running concurrent, they're not gonna assess the probation fee and your analysis fee in your case. That's why it's gonna go down to $32 a month. Okay?
Yes, sir.
Now, do you understand the state's offer?
Yes, sir.
You think the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Van Loo, I'll follow the plea bargaining agreement that you entered into with the state. Now, Ms. Van Loo, if you successfully complete the probationary period, this case will be dismissed. It will not, these cases will be dismissed. They will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Okay? So you're gonna stand in front of the clerk. Oh, just have a seat in that first chair by the wall. And just have a first chair in that first chair. Now, once the clerk finishes with you, you're free to go, and you have a blessed day. Thank you. Oh, I need to take that 500 off of this here fee form.
So you have bond forfeitures prior to our.
We don't have no bond forfeitures.
Okay.
Everybody showed up. Yeah. We'll be in recess till, we call it trial docket at 1:30. Okay. Jefferson County Court at law number 2 is back in session with the court's trial docket. First case that we're calling on the court's trial docket, actually, we have 2 cases, but the first case is cause number M330358. Case is styled the state of Texas versus Emmett Charles Young. State, are you ready to proceed?
Your Honor, that's gonna be a dismissal. It's not gonna be a bench trial.
Oh,
Emmett Young's are both of them are gonna be dismissed.
both of them dismissed. Oh,
Mhm.
we need a clerk to, just have a seat. We need to get a clerk so we can sign the dismissal. Okay. I had bench trials when this is. Okay,
Monday.
Jefferson County Court, Law number 2 is back in session. The court is in session and calls number M332534, case of style of the state of Texas versus Kiana Akish Kincaid. Ms. Kincaid, is that your full name?
Yes.
How you doing, Ms. Kincaid?
I'm fine. How are you?
I'm doing fine. Thanks for asking. Ms. Kincaid, you're representing your case by your attorney John Macy. Attorney Macy, how are you doing?
I'm fine, Your Honor. Thank you.
You're welcome. And the state is representing this case by Attorney Erica Porter. Attorney Porter, how are you
I'm
doing?
doing great.
State, are you ready?
How are you?
Defense, are you ready?
Yes, sir.
Now, defense, are you waiving your right to a jury trial in this case?
Yes, Your Honor.
And the state, you're also waiving the right to a jury
Yes.
trial? Okay, state, you may proceed.
Okay, the state's gonna call Kiana Kincaid.
No, you have to would you please read the information?
In the name and by the authority of the state of Texas comes down the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents into the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Kiana A. Chish Kincaid, hereinafter styled the defendant herein for 2-4 on or about May the 7th, 2022, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Kasha Kincaid, hereafter styled the complainant, by throwing a piece of broken plate that struck the complainant in the face, and at the time of said assault, complainant was a member of the defendant's family against the peace and dignity of the state.
And Ms. Kincaid, how do you plead? Okay. State, would you like to have an opening statement?
We're gonna waive it.
Defense, you're waiving your opening
Yes, sir.
statement as well? State, you may proceed.
Okay, state's gonna call Mrs. Kasha Kincaid.
Ms. Bailiff, would you please call
Kasha.
Keisha Kincaid?
Okay.
Okay, State, do you have another witness?
We don't have any more witnesses, Your Honor. That's our only witness, but we have to, I just want to add that we've made an effort to find Miss Keisha Kincaid. We've called her numerous times. The last time I called her, I received a phone call back from someone, left a message saying that she's not there, she's not available, and she didn't want to talk to me. So I made every effort I could to get her
Okay,
present in court.
okay, state rest,
Stay rest.
defense?
Your Honor, the defense would move for judgment of acquittal.
Okay, instructed verdict?
Yes, Judge.
Okay, Mr. Macy, that motion for instructed verdict will be granted. Ms. Kincaid, you have been acquitted of these charges. Our court clerk is going to be typing up a judgment. It'll take a few minutes for her to type up the judgment. Once you click out the judgment, you'll be free to go. And you have a blessed day. Case number is M332534, page 3 of the document. Okay, well, you need to have her to have a seat.
Yes, sir, have a seat.
Yeah, just have your seat and she's gonna call you up when you're welcome.
Your program is federal.
You'll know?
It's in federal. Where's Mr. Gall?
Okay,
Okay.
okay, let's see.
Brian, talk to me. He'll be here as soon as you can.
That was dismissed.
That's the one where you said.
Now, Richard is JP reduction. Young was dismissed. Do you have those dismissals on the, you did? There you go. Mr. Macy? Sure.
Here's one for you and one for your client. So you click on all.
Just sign those dismissals on, Young.
Mark.
And then for this.
That was, Kramer's dismissal just printed off. No, it's printed off now.
Oh.
The Emmett Young is, Galmore. Did, Mr. Galmore get his dismissals?
Not yet, I just printed.
He just printed them off. There's two of them.
Thank you.
Okay, we'll see you later. Okay. You still have another one on the docket?
Do not.
Oh, that's right. Richard was,
Yeah. I just-
JP reduction. Okay,
But he should be here shortly.
okay. Cause number M 331-988, case of style, State of Texas versus Leonard Greg Murphy. Please come forward. Today is 17. Okay, Mr. Murphy, I just received a motion to dismiss. In this case, I just signed it. Your attorney will be given a copy of this motion to dismiss. Once you get a copy of this motion, you're free to go. Let me ask something. Did we have bond conditions in this case?
He's still on a GPS.
Okay, we need to hit that motion to remove it. I don't see why it's not in the file. No, because I know, because yeah, I don't see, it's not. Yeah, I don't see, oh, wait up. Maybe, oh, it's on another page, on the next page. There it is. Okay. Okay, Mr. Murphy, the court has just signed the bond. The order to remove the global positioning monitoring system GPS. You're gonna get your attorney's gonna get a copy of it. Once you get a copy, you can give it to your client and then y'all can bring it to the facility under the business to get it removed.
Yes, Your Honor.
Okay? Did you get your dismissal?
Not
No, I
yet.
have it right there.
Okay, our clerk is gonna give you your dismissal. Once you get the dismissal and the motion to removing the GPS, you'll be free to go. You have a blessed day, Miss. Oh, that's right, you have another case.
Yes.
Okay. That one's dismissed. Jefferson County Code at Law number 2 is back in session. Code is in session and calls number M333732, case to style the state of Texas versus Justin Trey Bishop. Mr. Bishop, was that your full name?
Thank you, Your Honor.
Mr. Bishop, would you please raise your right hand? Mr. Bishop, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, Mr. Bishop, you may put your hand down. How are you doing, Mr. Bishop?
Good.
That's good. Mr. Bishop, you're representing your case by your attorney, Jared Gilthorpe. Attorney Gilthorpe, how are you doing?
Doing my best.
State is represented in this case by Attorney Kobe Hallpark. Attorney Hallpark, how are you doing?
Good job.
Mr. Gilthorpe, do you waive a record in Mr. Bishop's case?
Yes, sir.
Mr. Bishop, I have before me a document that is titled misdemeanor. It's information. This information was filed by Jefferson County District Attorney's Office. In this information alleged that you, Justin Trey Bishop, on or about December 21st of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Bishop, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Bishop, how do you plead? Not guilty, guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Mr. Bishop, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes.
On page 2 of the same document, there are a set of initials on the line next to the box that says check nolo contingent, which means no contest. Did you place your initials on this document?
Those are my initials.
And on the next document that is titled trial court certification to defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your next page? And is this your signature
Yes.
on this document?
Yes, sir.
Okay, at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that case?
Yes.
And I'm gonna go back to state's exhibit number 1 on page 3. Is this your signature above the line titled defendant?
Yes.
I also have another document here. This document is titled discovery certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled
Yes,
defendant?
sir.
Now, Mr. Bishop, before you sign and initial all of these documents that I just showed you, did your attorney, Mr. Gilthorpe, go over these documents with you?
Yes.
And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Well, I know.
Mr. Bishop, are you a citizen of the United States?
Yeah.
State, I have before me,
Proud
state.
Texan.
Hmm?
I'm proud Texan.
That's good. Now, Mr. Bishop, state, I have before me a document. Well, state, I have before me state's exhibit number 1. State, would you like to offer state's 1?
Yes, sir.
Any objections, Mr. Gilthorpe?
No, Judge.
No objections. State's exhibit 1 is admitted. Mr. Gilthorpe, you advised and counseled Mr. Bishop. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Okay. And Mr. Bishop, your attorney, Mr. Gilthorpe, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Gilthorpe, Mr. Bishop, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case? And what is that agreement?
Exchange for plea of guilty, no contest. State's agreed to recommend 1 year deferred adjudication, community supervision, $500 fine, and court costs, 60 hours community-based service. And in addition, interlock device to be installed. All other standard terms and conditions for a DWI first offense.
Mr. Bishop, state is often that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500. Those court costs of $457. You'll also be required to pay a probation fee of $60 a month, a year analysis fee of $15 each month, and a reimbursement fee of $15. You'll also be required to pay the DWI initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month is $170 a month. Will you be able to pay the $170 each month?
Yeah.
You'll also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate, you have to attend and complete DWI education class, and you will have a drug and alcohol assessment, and you will also adhere to the other standard terms and conditions of DWI probation. Now, Mr. Bishop, okay, we see this offense occurred on or before September 1st of 2019. Do you have a CDL, a commercial driver's license?
No.
Okay, and let's see. And there's blood alcohol wasn't above 0.15, is that correct?
That's correct.
All right, now, Mr. Bishop, do you understand the state's offer?
Yes.
Do you think the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer? Mr. Bishop, I'll follow the plea bargain agreement that you've entered into with the state. Now, Mr. Bishop, if you successfully complete this probation, this case will not result in a conviction on your record. You may qualify for non-disclosure. You can talk to your attorney, Mr. Gilthorpe, about the non-disclosure because he's quite competent in those matters. Now, Mr. Bishop, you're going to stand next to your attorney, follow the directions of the clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. And I thank Mr. Gilthorpe, this is the only case?
Yes, sir.
Okay, you're free to go as well and you have a blessed day.
Thank you.
Okay, just have a seat. She's going to call you back up. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. First of all, I'd like to apologize for having you out in the hallway. While you were out in the hallway, we were handling business here in court. We had a couple of lawyers who had to be in other courts, and the way the law is in County Court at Law number 2, if a person is in federal court, they have priority over state court, or if they're in district court, like some of the lawyers were, they have priority over County Court at Law number 2, or the County Court at Law. And so therefore, we was waiting on some attorneys, but those attorneys who were here, we were able to handle some cases. And so now we have this case that's on our docket. And the case is cause number M331988, case is style of the state of Texas. No, excuse me. Yes, sir. Case is style of the state of Texas versus Elgin Jenkins Jr., and that's cause number M333019. And you have been asked to come to County Court at Law number 2 today for jury service. You will be examined for inclusion on a criminal misdemeanor jury trial. Our court hours vary. They are normally from 9 a.m. to 5 p.m. However, because we have large dockets, we have a lot of cases in this court. We usually handle a lot of business from 9 to about 12 or 9 to 1. And then we start our trials at 1:30 on. Usually 1:30 to 5. And so if you are selected for inclusion on this jury, you are performing a significant duty that only free people can perform. If selected, you will be if selected on this case will be tried consistently with justice, which require a careful and correct trial. If selected on the jury, as I mentioned earlier, our court hours is in this case will be 1:30 to 5. You will be permitted to separate for recess, for meals, and at night. I must perform the first of 2 administrative duties. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the first oath, I need each and every one of you to say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for jury service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualification for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I'm going to ask a series of questions. I do not need you to answer those questions out loud. Just answer the questions to yourself. And once I ask the final question, then I will ask you, is anyone disqualified under the law? And if you think that you may be disqualified under the law, we're going to ask that you raise your right hand, and then we will ask you to come up before the bench one at a time so that we can discuss the matter more privately. And when I use the term more privately, what I mean is we'll turn off the mics, and then we'll turn on a noise device. And then once we do that, the other members of the panel will not be able to hear. Okay, so the first question that I need you to answer, just answer to yourself. Except for failure to register, are you a qualified voter in this county and state under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question, I always pause here because it's a question that I have to ask. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question now. Is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. At this time, we have juror number 2. Mr. Greenberg, would you please come forward? Now we'll determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions, but if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to remain seated. Now, I will ask these questions in the same manner that I asked the previous questions. We'll ask them in a series, and at the end of the series of questions, I will then ask if any of these exemptions apply to you, whether or not you desire to serve as a juror. Okay? And if you do not desire to serve as a juror based on one of the exemptions, just please come forward, and then we'll discuss the matter more privately outside of the presence of the other members of the panel. Now, first question. Are you over 70 years of age? Actually, the law has changed now. It used to be 70, it's 75. So if you're over 75 years of age, do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Or are you a student in a public or private secondary school? Or are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding the date the person is to appear for jury service? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? If any of these exemptions apply to you and you would like to claim them, please raise your right hand. 1, 2, okay. That's Mr. Torres and Mr. Thames, is that correct? Okay, Mr. Torres, would you please come forward? Ladies and gentlemen, now I will move on to excuses. And the way we're going to handle the excuses, I'm not going to ask any questions. I'm going to make about 3 statements. And then at the end of the statements, we're going to ask whether or not anyone would like to claim an excuse. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the district attorney and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone in the panel that would like to claim an excuse? If you'd like to claim an excuse, please raise your right hand. Let the record reflect that no one on the panel is claiming an excuse. Let the record reflect that all the members of the panel are qualified to serve as jurors in this case. Let the record reflect that the court has convened in this cause, being cause number M333019, and the case is styled the state of Texas versus Elgin Jenkins Jr. Mr. Jenkins is present in court with his attorney, Attorney Brandon Monk, and the state is present with Assistant Criminal District Attorneys, Attorney Courtney Davis, who's sitting second chair, and Attorney Erica Porter, who's sitting first chair. Our court reporter in this case is Miss Ada Christie, who's sitting to my left. So when you are asked questions or when you're answering, please speak up so that Miss Christie can hear what is being said. The bailiff in this case is Miss Veronica Woodle. Miss Woodle, you met her earlier. She's the person who will keep in law and order in this case. The defendant in this case, as I mentioned, is Mr. Elgin Jenkins Jr. And in this case, Mr. Jenkins is charged with a misdemeanor offense, and the misdemeanor offense is classified as a Class A misdemeanor, and the offense is deadly conduct. The range of punishment for a Class A misdemeanor, a person can be assessed punishment if convicted from 0 days to 365 days in the county jail, a fine from $0 to $4,000, or they could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more privately by taking off the mics and putting on the sound device. State, are you ready?
Thanks, ready.
Defense, are you ready?
Yes, Your Honor.
Okay, each side will be given 30 minutes for Bordar. I will be keeping time. Ms. Porter, the panel is yours.
Thank you. Good evening. I'm Erica Porter. I represent the state of Texas along with my co-counsel. And also, I'm going to be trying this case. My boss is Keith Gibbons. Now, the style of this case is state of Texas versus Eldon Jenkins Jr. You're gonna find out a whole lot of information today. Specifically, we're gonna talk about deadly conduct. Some of you might not be familiar with those terms, but I'm going to try to familiarize yourself, okay? I'm gonna leave this podium and walk in front of you sometimes so I can kind of get a little closer to you. Then I ask you a lot of questions. If you don't talk, I have nothing to pull from. So you just might get on my jury. But if you do start talking, then I can kind of eliminate you based on your answer. So I'm gonna need your participation. It's just like you're back in school, okay? And I will start calling on you individually. All right, so deadly conduct. What is deadly conduct? And I want you to look at the TVs that are across the courtroom, and they kind of spell out everything that I'm gonna be talking. Deadly conduct. A person commits an offense if the person recklessly engages in conduct that places another in imminent danger of serious bodily injury. Now, what does the code say? It goes on to say that recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another. Whether or not the actor believed the firearm to be loaded or not. So if you pointed a firearm in that direction, even if you didn't know if it was loaded or not, presumed to be committing that offense. Defendant, what do I have to prove? The burden is on me. I represent the state of Texas. I have to prove that the defendant on or about a certain date in Jefferson County, Texas, did recklessly engage in conduct, placing another in imminent danger of serious bodily injury by pointing a firearm at an individual. That's what I have to prove. And that's what I'm going to prove. So recklessness and danger. Recklessness and danger are presumed, remember. If the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded or not. Reasonable doubt. Texas requires the state to prove this case beyond a reasonable doubt. Excuse me one second. Now, Texas law doesn't give you a definition for what reasonable doubt is. However, we're gonna talk about what reasonable doubt could possibly be, so you'll know what you're looking for. What we know reasonable doubt is not beyond a shadow of doubt or all doubt. Okay, so there might be some doubt. However, what is it? It's not beyond unreasonable doubt. Best way to explain it, you will know it when you see it. What is an example of reasonable doubt? So minor details. If you have a witness that said, oh, the shirt was blue when I was at the scene, then gets on the stand and say, oh, no, it was red. That's a minor detail. Does that create reasonable doubt? I'm gonna start asking questions. Ms. Cardella, Charles, would that create reasonable doubt to you? Something minor? No. Anybody else agree with Ms. Charles? All of y'all. So let's try this. Who doesn't agree with Ms. Charles? Everybody agrees with us. Okay. One witness. Texas law does not require a particular number of witnesses to a crime. Texas law requires the state to prove this case beyond a reasonable doubt. Why? Okay, let's take the first one. Why do you think Texas law does not require a particular number of witnesses to a crime? Ms. Bush. Help her out. Somebody help her out. It might only be one witness. Right, okay, so you understand what your colleague said? Okay, so there might only be one witness available, right? So that's why only one witness is needed. Anybody disagree with that? Okay. Okay, case beyond a reasonable doubt. Now, anybody disagree with me having to prove my case beyond a reasonable doubt? Everybody think I should have to prove my case beyond a reasonable doubt? Okay. One witness ruled. Who decides where the crime occurs? Mr. Chapman. Who decides where this crime occurs? When a crime is being committed? Who makes the decision? Oh, this is where the crime is going to take place.
Person who's committing the crime.
Great. Everybody agree with that?
Yes.
Okay. Who decides when the crime occurs?
Thank
And who decides how many people the crime occurs in front of? So the defendant decides all these three things, right? In fact, it's what we expect in most violent crimes. The individual that is the defendant makes the choice on who decides where the crime occurs, who is in front of, and how many people is in front of. That's why it's only one witness needed, right? Okay. Texas law does not require a particular number of witnesses. Keep that in your head. Texas law requires the state to prove its case beyond a reasonable doubt. Therefore, if one witness can testify, one, and meet every element of the offense, and you believe that witness beyond a reasonable doubt, the law requires that you find that person guilty. One. Everybody able to do that? Are you able to do that, Mr. Paul? One witness. Okay. Credibility. What they say, how they say it, and why they say it. Okay, so credibility. When I say the word credibility, Mr. Hill, what comes to your mind?
It's believable.
It was believable. Add on to it. It's honest.
Trying to read the person.
All right, so
See if they're being honest or not.
that's good. And what are you looking at?
Can you add if their comments are consistent? It makes them credible.
Okay, good. And what about you, Mr. Rodney?
Background of the witness, where they come from, what they're involved in, to establish the credibility. Obviously,
And you, what about you, Mr. Crenshaw?
I think they just all covered it.
Do you agree with everything? Amazing, coming back. All right. All right. Can't get away that quick. What they say. Does it make sense? What to believe? All the testimony, some of the testimony, or none of the testimony? Who decides what to believe? In the trial. All the testimony, some or none? Who are you? Very good. Would you agree with that? Okay. This is not CSI. We're looking at a puzzle. Okay. Common sense. Now, there's a presumption of innocence. What does that mean? Miss Melissa Thomas? Okay, and tell me a little bit more about what you think the presumption is.
I have to believe that this man is innocent, and your job is to prove that he's not.
Absolutely, Miss Sanders, right now, if I ask you to go back into the jury room and come back with a verdict, what would your verdict be? Absolutely. Anybody else agree with Miss Sanders? Right now, because I haven't presented any evidence, have I? Just been talking. So I'm not guilty. Everybody has it. Means the state has to prove defendant guilty beyond a reasonable doubt. Defendant, what does he have to do? Essentially nothing. He has no burden. He has the power to subpoena if he wanted to. Right to discovery, right to a trial, right not to testify, right to exculpatory evidence, right to defenses. He doesn't have to do anything. The burden is on me. Things not required to prove. Motive. I don't have to prove motive. Who was there? And what are your duties? Decide the facts. Apply the facts to the law and follow the law. Mr. John Luckman?
Yes.
Can you do those three things? Decide the facts, apply the facts to the law, follow the law?
I can.
Anyone in here can do those three things on this panel? Who has had a firearm pointed at them before? You had? Okay. All right, so there's a lot of you. I'm gonna go starting with Cordelia, I'm sorry, Cordelia. Tell me about it. How did I do it? Were part of this implemented in your school? You go ahead and deal with that. And you did judge this case or be a jury on this case, fair, and all thanks to the decision of that. Everything's gonna go these next. Anybody else who raised their hand? You did, I'm sorry. Mr. Michael, what happened?
I don't know that.
What happened? What happened? What was the situation? Was it family members or random? Oh, it's one. How did it make you feel each time?
Too nervous.
Were you in fear for your life? Did you press charges against them? Either time?
No.
Oh. Right, Mr. Roger?
Yes.
I just-
Did a family member, your own, pointed a gun at me, and I have to admit, the first couple of seconds after second, I left it choking real pop in my britches, but you know, after that, I mean, I just took control and done. Not to be the person.
Did you persuade me or anything?
No,
Could you be a jury in this case and based on the evidence law? I think I missed somebody over here. Who was? Oh, tell me about this, Joe.
Oh, it was many years ago. I was in my teens,
Oh,
at a party, alcohol was involved,
and
and it was a situation where someone, was upset, happened.
okay, did. You thought so, did it-
Oh, no, there was a whole group of us. We
How
calmed
did it
it
make you
down.
feel? Okay. Oh,
I was worried about everybody else.
somebody else might get hurt.
Yeah.
Examples of evidence that may show a victim was threatened with a gun. Examples of evidence that may show an individual committed the offense of unlawfully carrying a weapon. So we're gonna go through examples of evidence that you want to see that may show a victim was threatened with a gun. What would you like to see at this trial, Mr. Benjamin? Terrence? I'm sorry, is that your name? Right. What's your last name? Okay. Okay, all right, I guess I haven't missed that, but tell me about what you would like to see at this trial, evidence that would show that a victim was threatened. What would you like to see? Eyewitness, so the individual himself.
Yes.
Okay, what about you? And- Okay, and what about?
The same thing.
Okay, so an eyewitness,
Testimony, video. Basically, yeah. That's the thing.
okay. All right. So example of evidence that may show an individual committed the offense of unlawfully carrying a weapon. We're not gonna take that one out. Prior jury experience. Does anyone know the defendant or his attorney? Do you know this individual, Mr. Jenkins? Okay, what about me? You know Eric Porter? Anybody? What about my co-counsel? No. What about you? No, you do?
Not directly,
Not directly. Or indirectly, how do you know?
work for kids,
Oh, okay, okay. What's your name?
running wide,
Okay, you working with now? That's my husband, by the way.
years prior.
Okay, okay, all right. But can you judge the case based on the evidence alone? Does anyone know me or my co-counsel Kobe? I'm sorry, Kobe has just stepped out. So no, another co-counsel. And you answered that question. Anybody can't sit in the seat of judgment. Meaning I can't judge anyone. I just can't judge people and I feel bad. I can't do this. Anybody that's now's the time to speak up. Okay. So I'm going to get a little nosy. Some of you have sat on criminal jury trials before. Michael McCarty? Okay, tell me about this.
If we didn't get to deliberate, they reached the verdict after they finished the testimony and we went for lunch.
Okay, so the defense pled out.
Yeah.
Okay. Right. And that was just that one time. Roger here?
Yes, I was only a jury on the murder case.
Okay.
3 years ago, murder involvement with the Holmes.
Did you read that?
Yes, yes,
Did y'all say something?
yes.
Clifford, Crenshaw.
Yes, sir.
Okay, what's in the budget there?
It was a federal court case.
Oh, Billy, okay, did y'all read your verdict? Y'all said something. Melissa Thomas. Did y'all read the verdict? And y'all said something. Go ahead. The judge said something. Roger Hodges.
Yes.
Tell me about the case.
Homicide. We judged it, you know, I mean, we sentenced and everything, went through the whole process.
Did you read the verdict?
Yes. Well, yeah.
Did y'all say something?
Yeah, that's what I mean.
Right. All right, any questions for me? Now's the time to ask. Anybody have any questions for me? Well, I thank y'all for entertaining me this evening, and I look forward to picking this year. Thank you.
Mr. Monk, the panel is yours.
Good afternoon. Thank you all for being here. Truly do appreciate y'all being here. This type of space is extremely important for my client, Mr. Jenkins. You don't know him. You will get to know him. This is a case where I do expect he's probably going to testify and tell his side of it. I think this is the case where there's going to be a swearing match. And this issue that's been brought up already about, well, how many witnesses do there need to be to convict someone? Well, you know, in reality, it takes one credible one, right? One credible one. And I think it's important to keep in mind that credible one could be the person that's accused of the crime. And so does anybody have a starting point problem with that statement that I've made? That look, Mr. Jenkins is here, and I think just because he's here and he's in this seat, that I'm gonna have a hard time maybe believing some things that he says. And I really do want you to talk to me about this issue. There's not a wrong answer in this. It's not wrong if you tell me, look, I'm gonna be honest with you. I feel like there's a little, you know, just a little taboo of even being in this chair. So does anybody feel that way? Does anybody feel, well, look, he's accused, he's sitting here, and as a result of that, I'm probably a little bit less, 1% less, one tick less from believing him as a result of that. Does anybody please raise your hand at that here moment? Okay, that's good. So that's one of the things that we'll ask you to do in this case. That's extremely important is to please consider our side, right? Just because we're being accused and we're in this situation in our system, as y'all acknowledged in some of the questions from this quarter, that doesn't necessarily mean we're guilty. In this case, we're not guilty. Okay, adamantly not guilty. One of the things you'll be asked to look at, and it's consistent with what Ms. Porter talked about, is, well, where did this event occur? And I think that is an extremely important fact for this case once we get into the facts. But in a situation where somebody's accused of maybe, you know, deadly conduct, they went and instigated some situation, would it be important, I want to see a show of hands, important for you to know where the incident occurred? In other words, our property or their property, that kind of a situation. Who thinks that would be an important fact to know in terms of where this occurred? Okay, so we have almost unanimous Mr. Charles, I'm sorry, I'm gonna pick on you only because you didn't raise your hand there. Is there a particular reason that you have some maybe disagreement with that statement that you could talk to me about?
I think the facts of what occurred are more important setting where said incident occurred.
And so I think the idea would be that maybe some of this idea about the setting does talk about how it occurred, the events that went into that. And so do you have a problem considering that in terms of location as part of your decision-making process in a case like this?
No, if somebody was a dog park and they got bit, that'd be a lot more likely than if they were in the middle of a hospital and got bit.
Or that's great. That's a great point. Let's say, my property versus their property. Does that make a difference to you? Fair enough, fair enough. Ms. Bush, can I ask you to reason with me a little bit? And I'm not asking you to weigh all the facts of the case, but just looking at this idea about this fact of where the event took place, in a situation where there's an allegation of deadly conduct. Talk to me a little bit about how you would reason through that.
I agree with it, depends on the facts of the case, protecting the property and protecting self. Those things were things that were very.
So the protecting self aspect of this, let's say that hypothetically the facts would show that there was a charge with a vehicle towards Mr. Jenkins, and that he pulled the weapon to defend himself. Would that be significant? Okay. And Mr. Chapman, carrying on that line of thought, could you talk to me a little bit about what kind of facts you'd want to see?
Yeah.
Yes, sir. Can we approach that?
Yes, hold on a minute. Hold on, wait a minute. Yes. You may proceed.
Thank you, Judge. Mr. McCorvey, self-defense, what kind of facts would you want to see in a self-defense case if you were going to listen to that defense, consider it, and make it part of your decision?
I'm not positive. I think it depends on what the law says is a rational or legal reason for self-defense.
But you would agree that you can listen to those facts and try to make some decision and take into account that there may have been a reason that a firearm was used. Very good. And do you agree that there are reasonable justifications for why somebody may pull a firearm to defend themselves? General question for the group, and this will be one where I ask you to show your hands again. Is there anybody that feels that really nobody except for law enforcement should have guns? That they're the only ones that are in the business of having guns and they are trained and that nobody else out in the street should have guns at all? Is there anybody that feels that way? Raise your hand, please. Okay. So everybody feels that you have the right to have a gun, you have the right to use the gun to protect yourself under certain circumstances. Is that fair for everybody? If you disagree with that, please raise your hand. Okay. So it just really all comes down to the facts of the case. Is that what we're all sort of getting at here? We want to hear that side of it as much as we want to hear maybe the one witness that complained about what happened. We also would like to hear, well, what are the circumstances that might have caused this to happen? Ms. Hollis, I want to ask you about this concept of using a gun to defend yourself. All right. I'm assuming you've never done that before. Okay. So is there a circumstance that you could imagine where you would say, well, look, I would do that? Okay.
Absolutely, I've got children.
So very good. So there is a circumstance within the realm of possibility where you would think that would be a reasonable response to the circumstances.
That's life and death.
Ms. Hicks, same question for you. I'm interested in this concept of self-defense. And some people, quite frankly, will tell me, look, I don't think that there's ever a time you call the cops, right? You call the cops is what you should do. You should never be pulling a gun yourself, even if you're not gonna fire it, you should never pull it. How do you feel about that?
I believe you have to watch the future stuff.
You do.
It's a gun.
Mr. Wise? Same.
Likewise, I feel like when it's dealing with my life, my property, my well-being, or my kids, or my family, I think I would have the right to do so.
Very good. Mr. Crenshaw?
Yes, sir.
Same question for you. I mean, how do you feel about this concept? Is there a circumstance where you think that that can be reasonable?
Defense of family and neighbors or.
And is there a circumstance where you think that if you did it the right way, that that conduct would not be deadly conduct? You hesitate a little bit, so I have to ask.
Well,
So
I'm
tell me-
just doing the deadly contact. If you ever use it, it's deadly force. So does that go into deadly contact or not? I mean, you did it, they did, deadly contact.
That's a good point. So the charge that they're making is not contact. I do want to be clear about that. This is not a case where anyone was harmed or injured. Okay. Instead, what we're dealing with is, well, there was some kind of a action, and then my client took a reaction, but that reaction did not include fire.
Okay. You want to object on the record?
Yes, sir.
You can make your objection.
Okay, Your Honor, again, he's getting to the facts of the case, and it's not proper to do that during voir dire. So we're asking for him to rephrase his question if he's making a question, but he's, number one, he's arguing, and he's getting to the facts of the case.
So, okay,
Summary and brief introduction of the facts is all I've done. I haven't gone into the detailed facts of the case. And we're talking, just trying to get feelings from the jury about those issues. So
This is not.
in court hour, we're entitled to introduce the case. I think.
No,
Your Honor.
okay, so I'm gonna sustain the objection as an improper commitment question. And an improper form question, so you can rephrase your question.
Very good. Thank you, John.
Is there anybody here that's familiar with a bait shop out on Highway 365 that is called Luck in the Bucket? Okay, all right, so I'm gonna take you one at a time here and go through this. Ms. Bush, we'll start with you.
Use them and I live down.
Okay, so you're a customer of Luck in the Bucket. And are you familiar with that business location?
Yes.
And you've gone there yourself? And you've been in the store and you've seen whatever goes on in that store? Okay. Yes, sir. Mr. Chapman, did you raise your hand?
I did,
Okay, what's your experience with Luck in the Bucket?
exact same as this attorney.
Okay,
I fished, I used them for bait, I've been there and purchased bait.
and so you're familiar with the exact location that
I'm
it's
familiar with the exact.
Okay, what's your objection?
Okay, again, he's getting to facts of the case. We just need to know why you're talking about about the Luck in the Bucket.
Well, these are the parties to the case. And so if there's going to be a witness that comes to the case and testifies, I'm entitled to ask the jury about whether they know that witness that might be a potential witness in the case. This is also the location where this is alleged to have occurred.
Okay,
Could you I guess state the names of the witnesses? You have a right to state who and whether or not they know.
The business for the witnesses is Luck in the Bucket. Can I state the names with the business name?
You can do that.
Thank you, Judge.
Okay, you may proceed.
Okay. Continuing on with those that know Luck in the Bucket and Ricky Lane, who I believe the witness will testify in the case, who is the owner of that business with Deronda Lane. Now that I've said the names of the individuals, if you could once again raise your hand if you recognize the names of the individuals that run Luck in the Bucket business. Covered all but in the back row. There were a few names over here for Luck in the Bucket, I thought. Do you recognize the Ricky Lane name as well? Do you recognize Deronda Lane's name? Do you know the site or you visit that
I
location?
drive by it. I live in Fort Acre, so I drive by it.
Are you a customer?
Yeah.
Thanks. Yes, sir.
Possibly recognize the name,
Okay, and which name do you recognize? Ricky Lane?
listed on them.
He is, I think he has some disability. I think he does. Yes, sir. Do you know him?
Yes.
And how do you know him?
Okay.
Did y'all go to school together?
Yes,
Okay. About what grade did y'all
we
go?
were in the same grade.
You just knew him through school.
And it was
What school was that?
Sam Houston Elementary School in Port Arthur.
Yes, sir, on the back row.
I used to keep a boat down to be fast, so I always thought I'd get bait on the way down my boat. So that's just how I know the story.
So you're a customer of Luck in the Bucket.
Well, I used to be, I don't have to.
And do
I
you know,
haven't used it, and I haven't been by there 4 or 5 years.
and do you know Ricky Lane?
I don't know him, but I've been around him when I obviously go about the store. But I don't know him.
And how about the Rhonda Lane? Anybody else that I didn't cover who has some knowledge about Luck in the Bucket, Ricky Lane, or Deronda Lane?
I just know where it's at, that's all.
Have you ever been there as a customer?
No.
All right, so my client is Mr. Elgin Jenkins. He owns the property on Highway 365 that is right next door to the Luck in the Bucket. And so now I'm getting some
Yeah,
reactions.
we've gotten wood from him before. I thought the name sounded familiar, but I couldn't place it, so I didn't know if I.
That's great. So you're coming forward now to tell me, now that I've told you a little bit more about the parties, you certainly know both parties in the case. And as a result of that, you think that you should not be a witness, I mean, a jury in the case. You think you should not?
I should not.
Okay. And Mr. Chapman?
Yeah, so the only thing I know is I am a customer and I bought bait as a bait shop before. I have heard people refer to him as Ricky. I didn't know that was his last name. I don't know the Rhonda lady. I have had a lady wait on me there before and sell me bait. I do know that there is a firewood place next door and that recently, in the last year or two, they had to change the driveway. And go in, they used to share one and I heard there was something and then now we have to go in another way. That's about all I know. I don't know him, I don't know them, I don't know the wood business, never bought wood, all I did was stop by and buy bait, so you be the judge.
But no, I appreciate that. And I appreciate your honesty. I truly do, because right now we're just trying to figure out, can we see a good jury and a jury that would be fair? And
I don't know the guy personally, nor do I know him, so if the facts of the case would have to come before me before I make any judgment.
okay. So it sounds like to me, you do know a little bit of the history of the driveways.
I do know that they shared a driveway. I think they shared a driveway, they're next to each other. And I want to say, if I remember right, some, maybe that business even put up a sign at one time to where they was fussing, saying like, don't buy stuff from something.
Which business put up a sign that you can remember?
Maybe the Luck in the Bucket, I don't know.
Okay.
But they ended up doing the fence and changing it up and putting the driveway through this way, through their own driveway to the Luck in the Bucket. Again, I don't know the people, all I know is I stopped by there and get paid.
Thank you, sir, very much. I appreciate you. And now that that's been sort of talked about, is there anybody else that refreshes your memory that you know a little bit about the circumstance, you maybe know about the drive or anything to do with that? That's okay. Very good. So one of the things that we have to ask you to do in this case is, at the end of it, you're gonna be asked to make a decision about my client's guilt or innocence. We take that very seriously. We hope that you'll listen to all the evidence of the case. And if for some reason you just feel like you're not able to do that, you could not do that for us, and we'd rather you just speak up and voice that, and let us know that. There's nothing wrong with saying that at this stage. There's no real wrong answers to anything. And this is probably one of your only opportunities in the case to ask me anything, to tell me anything that you want to tell me that you think that I should know that's important that maybe I've left out of these questions, or just to talk to me about something that maybe I've made confusing or that you have a question about. Then when the trial starts, you're not going to get that opportunity probably till the end of the case. And so I want to give each of you an opportunity now to say anything that you want to say to me, and there's no wrong answers to any of this. Does anybody have a question of me or anything they'd like to address to me? Okay, well, with that said, we just ask for your agreement that you will consider our side of the case and judge the case fairly. Thank you all very much for your time.
Okay, ladies and gentlemen of the panel, we're going to ask that you follow the bailiff into the hallway. And while you're in the hallway, we may ask some of you to come back in for some follow-up questions. So at this time, would everyone please rise as the panel exit the courtroom? Please follow the bailiff. Okay, you may be seated.